Today's video is pure courtroom chaos, traffic excuses, probation drama over marijuana, and a so-called whistleblower blaming everyone but himself. 3 different cases, 1 shared problem, no accountability. Watch how fast confidence disappears when evidence shows up. Let's get into it.
This is 24 RO09007. Mr. Sutton, your ticket was issued for improper passing back on the 26th of November, 8:29 in the morning, southbound I-75 near Lincoln. You've got 3 options in this matter. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
With those choices, it would be admit with explanation.
Okay, and what is your explanation, please?
It would be kind of hard to explain it. Is there any way that I could flip my camera around and show you? Hold on 1 second. I'm not sure. Oh, there we go. All right. So this is 11 Mile. This is the on-ramp. This is me. Basically, when I got on the on-ramp, you got cars that were cutting across the 2 lines, cutting in traffic. Then I saw a cop car and a car in front of it, which I thought the dude was broke down and he was just sitting there waiting, how sometimes the officers sit there while cars are broke down, because whatever. So I come up and I gently just kind of went around him because the on-ramp was clear to go on and I was going to 696 westbound. So I would have stayed in his lane. And apparently he didn't like that, and he came after me.
But you drove on the shoulder, did you not?
Like a foot, not easy.
So you drove on the shoulder then?
Like barely.
Barely, slightly, completely. It's all the same. You drove on the shoulder and violated MCL 257.6372, which specifically states that the driver of a vehicle shall not overtake and pass another vehicle upon the right by driving off the pavement or main traveled portion of the roadway. So by legal definition, you violated this law and committed a civil infraction.
Like I said, you have all these cars cutting across the lane. I thought it was a broke down situation because you got cars cutting across double lines into traffic behind him, and it was wide open in front of him. So at first I thought that was a situation between them 2 cars, the officer and the other car. And like I said, I come up the ramp, I was sitting there, then I was like, okay, is this guy broke down or what? And no one was moving, so I needed to go straight. And that's kind of what I did. I mean, obviously, an officer sitting there, I ain't gonna be like, hey, let me break the law in front of him. But that's kind of what happened.
Yeah, it is. That's exactly what happened. You simply can't drive on a shoulder.
Right, but driving on the shoulder, 4 tires, that's one thing.
Driving on the shoulder is one thing, and that's the only one thing. It doesn't matter if there's 1 tire or 4. You can't drive on the shoulder.
Okay, but how can you have other cars crossing double lines then?
Sometimes you have to wait.
Explain that.
I can explain that this is your 3rd ticket in a year.
Where that has nothing to do with improper lane change. Even the officer car was across the line, passing. So he was improper to begin with. So how was...
Mr. Sutton, are you admitting or denying?
I told you that...
And I understood that you said yes. You admitted responsibility. You rightly admitted responsibility. The fine is $130. It can be paid online, by mail, or you can pay it at the courthouse counter.
And what's the points on this?
That's between you and the Secretary of State. The court doesn't give the points. I can tell you.
I revoke I'm not guilty. I'm claiming.
Good luck with that, especially since you just admitted to the infraction both verbally and with your 3rd grade art display.
Because the cop was over 2 lines. He was between these 2 yellow lines. And why? Because there's 2 lines you ain't supposed to cross when you get on the on-ramp. People are already crossing it. I told the officer when I got out, look at all these people cutting across. How am I supposed to know what you guys are doing? And he, like the officer said, you are responsible for your own actions. Exactly. I safely cruised around him. I didn't fly around him. I did 2 miles per hour, just creeped around him. thinking that car in front of him was broken down.
If you want the hearing, you'll have to stop talking so we can start it. Raise your right hands, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
Yes, Your Honor.
The officer will testify first.
All right, thank you, Magistrate. On November 26th, approximately 8:29 in the morning, I was in unmarked car 805. I was dispatched to a call on westbound 696 as there was heavy traffic backup due to large spill of dirt, probably from some sort of commercial grade vehicle. Traffic because of this was incredibly backed up on southbound I-75. I was on the on-ramp from southbound Stevenson, which is essentially, it's considered the 11-mile on-ramp, but it's the start of the on-ramp basically starts just now north of 4th. And I was fully within my lane. There was cars in front of me trying to merge over into the stop lane of traffic. Prior to the construction, that on-ramp lane continued as one continuous lane to 696. However, since everything's been constructed and redone, it no longer does that. It merges onto actual lanes of traffic and does not continue as one continuous lane. I was waiting for my traffic to clear so that I could continue forward and also merge over. While I'm waiting, the vehicle driven by Mr. Sutton, which was a 2013 black Jeep Grand Cherokee, drove past me almost completely on the shoulder. Not by just a couple of feet, but almost complete. If I am allowed to admit into evidence, I would like to admit my dash camera video into evidence to further support my testimony.
Okay, can you play that now?
Yes. Give me one moment to get everything pulled up.
This is where it falls apart. He says just one tire, but the dash cam shows the whole car on the shoulder. The law doesn't care about barely. Once he backtracks after admitting guilt, his credibility is gone. Sometimes arguing costs more than the ticket.
Are you able to see it?
Yes.
Okay. Magistrate, would you like to see that again?
Please.
Magistrate, further, I would like to add in testimony that I had no rear lights on to indicate that I was behind any traffic that was disabled or anything. As my video clearly shows, I was within my lane of traffic, merely waiting for vehicles that, again, were within their lane, attempting to merge over into a merged lane into basically what was equivalent of stopped traffic in southbound I-75. Let me pull up this again. All right, can you see me again?
Yes.
Share. Okay. All right. I have no further to add.
Mr. Sutton, you saw the film?
Yeah, and I'm assuming that's sped up, by the way, because the officer
Did you
was
see
sitting
the
there for a
film,
good
sir?
minute. Yes, I see the film, but
Did you
as
see
I
the
asked,
vehicle
it
on?
sped up.
Did you see the vehicle on the ramp?
The
did you
vehicle
see
that was
the-
in front of him, yes.
You had told me that you only had one wheel over on the shoulder.
That's what it looked like to me.
Well,
When I went
did you
around
see?
him.
Did you just see the video that showed all your entire vehicle driving down the shoulder?
Yes, I did. But as I said, he was sitting there with no lights on, no nothing. Is that video sped up? Because I
It's-
waited for
it's,
a good minute before he even moved.
Mr. Sutton, your testimony isn't true.
What do
The
you mean?
picture
Isn't it
shows
true?
you drove through on the shoulder. You had said
I never said I
repeatedly-
didn't.
Yes, you
I
did.
never
You
said
you
I
only had
didn't drive
one
on the
tire
shoulder.
kind of on it.
I said I was a couple foot over the line with the right
We're in a
side.
couple feet. It was the entire vehicle. Pay your ticket. We're done.
Mhm.
Man.
Real quick, does he have his back view? Because I would love to see that. So you can
You know,
see
I
what
would
was
just
seeing.
like to have you stop talking.
No.
I don't need a back view. You can tell from the front exactly where I am and exactly how I am. You don't get to just drive around people. He doesn't get it. He didn't get it there. He doesn't get it now. That video doesn't make it any more clear.
It couldn't be any more clear. Back view. We don't need it. He repeatedly said just one type, couple feet. And not only that, the rate at which he drove past you could have given rise to another ticket.
If that was sped up, then like you can clearly see, you can see the timestamp right up. Everything is going at exactly the same time.
Real time.
Yes, there's no change whatsoever.
Well, that was fun.
Yeah, I figured you'd like it.
Yeah.
I think if you would have actually played the YouTube back to him of him repeatedly saying, I just had one tire, he still would have denied that too,
Yes.
for sure.
I love these dash cameras. I love these body cameras. I have nothing to hide. They are a phenomenal tool. They only make my job easier and they only back up my credibility.
Sit for him. People can make an allegation and it's hard to unring the bell. When you've got it on film. There was a case not so long ago about an allegation of a prisoner in the back of a vehicle said that police officers stopped when they were bringing her to the station and committed all kinds of nefarious acts on her. They had the film timed, and it showed her the whole time.
Mm-hmm.
And the allegations that she made against those two men were criminal acts
Yes.
and could have resulted in them going to prison.
I sure hope she was charged because all too often I find administrators not willing to charge for false report.
That's a felony.
Yes, it is.
The State of Michigan versus Dawn Crow. It's file 23-42445-SM, also set for a probation violation today. We have Ms. Crow with us. All right, I do see Ms. Crow. Ms. Crow, can you hear me?
Yeah, I can hear you.
All right, thank you. Excuse me. You are charged with a probation violation. The allegation made against you is that you were non-compliant with your probation in that you failed to complete the retail fraud class, the work camp days, to report for the month of July, pay fines and costs and test as required. You have previously had a technical violation back in May in that you failed to complete the economic crime class, 3 work camp days, and pay your fines and costs, and your probation was extended. The recommendation for today is that you extend probation 3 more months, do community service in place of the work camp due to moving downstate. Do you understand the nature of the allegation made against you? Do
Yes, sir.
you understand the recommendation?
Yes, sir.
How do you want to resolve this matter?
I would like her to extend my probation just because I did move downstate. I do have a job, so I'm trying to pay everything off. I actually am sitting in the hospital right now. I had to have emergency surgery last night.
I'm sorry to hear that.
But I did move down here so I could at least work and try to pay everything off.
All right, the recommendation is not only that you pay stuff off, but that you do some community service work instead of the work camp days. So the work camp is typically here in Otsego County. Community service work could be at a nonprofit or a community service organization where you're living at. But it
Okay.
would need to be additional things to be done. Are you gonna be able to do that down there?
Yes, sir. There's actually a Salvation Army and a Goodwill down here that I could definitely volunteer at.
All right, you're gonna need to talk about that with your probation officer ahead of time.
Now, sir, do I still have to drug test because there's no like this substance abuse issue with my case at all?
Ms. Hill, what is your thought?
Your Honor, I leave that up to you. Ms. Crow has not done well on probation at all. She's not calling the testing line. She hasn't tested. The only reason she's getting another chance right now is because she called me, said she got a job and that she's doing better. This is her last shot. Her next time that she comes before you, I'm requesting jail.
Can I respond to that, Your Honor?
Yep.
I have been calling the testing line. I have been doing the testing line online every day. The reason why I have not been able to test is because it's $45 every time I test, and I owe the testing facilities almost $120. I'm not made of money. I pay my child support $300 a month. I have a $260 car payment and $120 insurance payment. I am trying to get a place of my own, which is another $900. I'm not made of money. I do not have the money to, but I have been calling the testing line. And on reporting this month, the reason why I missed reporting is because I was at work. I have been working my tail off. I called to report when I realized that I missed it.
Okay, Ms. Crow, who made you do the retail fraud 3rd degree?
Nobody made me do it, Your Honor.
So you got yourself in this mess, right?
You're right. I was retarded.
Agreed.
I should have known. I should have put it back. It was a big mistake. I have never stole anything else in my entire life,
Okay.
and
so,
I never will.
Good. I'm glad to hear that. As a result of that, Judge Cooper, back in October of last year, gave you a court order, which was to do certain things.
He
and
did. I understand.
You've not done those things. And so it's a little hard for me to understand why I should take things off of your plate that the judge ordered when you haven't done them.
I
And
understand that, but
I understand that life is hard sometimes and life is expensive sometimes.
But why am I being drug tested when there's no substance issue with my case whatsoever?
What kind of a store did you go into to steal from?
It was a sex shop, and I stole fuzzy handcuffs.
It says the Fantasies Smoke Shop.
It was a sex store, Your Honor. The smoke
right.
shop is a porn store.
I wasn't the one who sentenced you, so I can't tell you why the judge put that in place. All I can tell you is the judge did put it in place, and you've not been doing it.
Because, Your Honor, she will violate me. I admit I smoke marijuana for my autism. It is the only medication I am on, and I told her this. And
So what doctor prescribed marijuana for autism?
it's not prescribed, it's recreational. It's the only thing that helps.
How do you know that?
Because I've been on multiple medications, Your Honor. I have been on almost every ADHD medication that is known to man. I was a guinea pig for a very long time. When I take 2 hits, I can finally feel normal. I can function.
Now you can feel stoned is what you can feel.
Your Honor, it's not like that. It's recreational for me. I don't do it all the time.
Do you understand what recreational means?
It's because I don't have a medical card. That's why it's recreational. If I had a medical card, it'd be medicine.
You're telling me you're using it for medicinal purposes, but you have no doctor that's prescribed it. I've never heard of marijuana being used for autism.
$275. It's $275 to go get a medical card. I don't have that kind of money. So I came down here. to try to get everything done. So I actually had the money to go get the stuff that I needed to get done.
Stop smoking marijuana, you'd have money to do your drug testing.
I'm not gonna stop smoking. I'm sorry. That is my medication. That is the only thing that helps me function. I have seizures. Not gonna happen. I am not gonna have a seizure because I had a withdrawal from marijuana.
Seizures is a medical problem. What is your doctor prescribing for your seizures?
I'm on gabapentin for them. It's a nerve blocker.
So how does the marijuana stop you from having seizures?
Because it is a proven fact that marijuana and CBD oil, when given at a direct time for a seizure, it can stop it instantly. They give CBD oil to
And how do you
seizure
know
patients.
that? How do you
Because
know
it's
that?
happened. Because it's happened, Your Honor. I've witnessed it myself.
Your
I have
Honor,
dropped
with her
seizures.
attitude in court, I'd be willing to change my recommendation to 10 days jail and discharge her.
Why? I don't have an attitude. I'm down here working. I have a job. I have to go to work tomorrow.
You don't
I
have an
can't lose my
attitude?
job or I lose my son.
Oh, man.
What attitude
This-
do I have, Your Honor?
You just told me that you weren't going to do something when I asked you if it was medically done or not. You said
Because
the,
it
the
is
only
to
thing
me.
that-
It's medically
Ms. Crow,
necessary.
Ms. Crow, just wait. You asked me why, and I tried to explain it, and you're talking over me. The only thing that you've cared about is your marijuana. The
No,
only thing that you
actually,
got
it's
riled
not.
up. Ms. Crow, I'm still talking. You can't talk over me.
But I moved to get a
The
job
only
so I
thing
can
that you
get off
got
of fucking
fired-
probation.
Ms. Crow, stop talking.
Because you're making me look like a monster.
Ms. Crow, stop talking. I will give you an opportunity to respond in a minute. The only thing that you got fired up about when we were talking was your marijuana.
No, it
Do
wasn't.
you want to know why the judge originally, on my view, why the judge originally said you had to be drug tested? Is because the only thing that you're fired up about in life is your marijuana.
No, it's not, Your Honor. That is a bull-faced lie.
That's,
I came down
that's
here to
my
get custody
opinion
of my
based
child.
on your actions.
I came down here to get custody of my child, who I am fighting full custody for. That is
Probation is simple: follow the rules or go to jail. When asked to stop smoking to comply, she refuses. That's defiance, not defense. Money problems don't cancel court orders, especially when custody is involved. The judge gave her one last chance. We'll see if she takes it.
So, Ms. Crow, do you want to do all of your probation requirements, or do you want to do 10 days in jail and be done?
I will do all my probation requirements. I'm not going to jail. I have a 6-year-old child that I will lose if I go to jail. I ain't losing my son for nobody.
This isn't
I
about
fought way too hard for 6 years for that boy. I'm not losing him for nobody.
Good, then give up your marijuana and do what you're supposed to do.
There's no, where can she at least send me a list of places to drug test down here? Because there's no place to drug test.
Should have thought about that before you moved down there. Yeah, she can.
Okay, so either move or live in a tent and be homeless.
Ms. Hill can assist you if she can find some drug testing places down there. She'll send you a list. I'm
Okay.
going to adjourn this. I'm going to adjourn today's hearing for 3 months. You will follow
Okay.
all. Ms. Crow, be quiet while I'm talking. You will follow all of the probation requirements in the next 3 months, or you will do 10 days in jail. Okay? So I'm going to
Yes, sir.
adjourn today. I'm going to adjourn today's hearing. You got 3 months to show me what you can do. Do you have any questions?
Yes, sir. No, sir, actually, I don't.
You know what you need to do.
Yes, sir.
Ms. Hill will try to find a list of places where you can drug test. You must do every drug test, every community service work, everything, or we're going to have a problem. You understand?
Yes, sir.
All right. Talk to you in 3 months.
Okay, thank you.
Next case the court has is Jeff Hodges versus Andrew McCune. That's file 25-40756-GC. Set for a motion this afternoon. All right, if I could have the parties state their names for the record, please, starting with counsel.
Good afternoon, Your Honor. Matthew Kassar here on behalf of the defendant, Andrew McCune.
All right, and Mr. Hodges, you want to place your name on the record, please?
Hi, good afternoon, Your Honor. I'm Jeff Hodges.
All right. I have a motion from counsel for summary disposition, and I have a dismissal document from Mr. Hodges asking me to dismiss the case, and then I was handed today a form that's been mostly almost blacked out, so it's unintelligible for Mr. Hodges. So I'm going to ask Mr. Hodges first, what is this document that you sent to the court or dropped off at the court today?
This shows the criminal matter has occurred by Mr. Andrew McCune and the legal counsel for interfering attempts to interfere protected activities.
Mr. Hodges, this document doesn't show me anything. It's so blacked out. I don't know if you can, I know you can't read it from there, but it is without a doubt, there's about 6 words in total that I can read, none of which have any relevance to anything. I can read the words from, subject, date, to, FOIA, exempt, and then there's a federal court statute, 31 U.S.C. 5323, but it doesn't tell me what case, when, where, how, or why. So this document is absolutely useless.
I cannot tell you the details because of the federal regulations and the confidentiality requirements. But because of this matter, I'm falling under the federal statute outlined in that particular paper. And any attempt to interfere that a protected activity is violating the criminal law. And the law is cited on the title, the confidential FOIA exempt, and the word after that.
The Freedom of Information Act has absolutely nothing to do with this case or a criminal case. There might be contempt or there might be some sanctions for violating a Freedom of Information Act request, but Freedom of Information Act is simply a discovery mechanism with absolutely no connection to this case that I can see at all.
It's because of the law, how it's designed. This whole matter is FOIA exempt. And attempt to interfere.
I don't understand what you just, sir, hang on a second. I don't have any idea what you just said. This whole case is under the FOIA? That makes no sense to me. Explain that.
Because of the activity I did under the word after FOIA exempt, the 31 USC 53, as you can see, the information, as you see now, has to be redacted because of the confidentiality requirements. And
are you claiming to be a whistleblower, sir?
You are correct.
How does that have anything to do with this case?
And the counsel has tried to use irrelevant material that is a part of the investigation against me, and either intentionally or unintentionally, that constitutes the witness intimidation.
Do you have a court order from the federal district court that says that we can't do anything in our case?
I don't know. This is way beyond a civil court.
Says who?
Well, this is a federal criminal matter, and I don't know why someone thought it's a good idea to get involved in this whole matter and keep going after me. And I think the action by which him and the CEO is very unwise.
Sir, I don't know that this is a federal criminal matter. You sent me a piece of paper that has on it the words FOIA exempt and a statute number. I don't have any idea that this even applies to you. I don't have, this document shows me absolutely nothing. So there's nothing that this paper does or has or will have in this case. It's got nothing to do with this case as far as I can tell. I don't have an order from the court that says I can't do anything today.
The Exhibit A is violating the law cited in this paper.
I don't know what Exhibit A is.
That is your document presented by the legal counsel of your defendants. Also, the defendant's activity invoke your violation under the law cited.
All right, Mr. Kasser, do you want to respond to that?
Your Honor, I guess several things. I haven't seen the document that Mr. Hodges provided to the court today, and I'm nearly positive it makes no difference. There's no criminal matter here that I'm aware of, not involving my client, Mr. McCune. Last week, I believe Wednesday, maybe Thursday, Your Honor's clerk gave me a call and said Mr. Hodges wanted to voluntarily dismiss this case. I spoke to my client and we said that's, we will consider that, but we would need to have the dismissal with prejudice so as to end this frivolous action. Mr. Hodges has not provided any contact information, so I wasn't able to contact him by today's hearing, so I figured we could potentially hash out the details of a dismissal today. Now, given these new, I'm not sure if they're allegations or into myself and my client, I'm not sure that my client is going to want to drop this motion, which seeks sanctions, seeks fee shifting for what we've had to do to dismiss the several cases that, by the way, Mr. Hodges has brought. Mr. McCune and previously Ms. Sheldon, who this court dismissed that case a couple weeks ago, who did not bring any cases against Mr. Hodges, has not pursued any action against Mr. Hodges, terminated him for a reason, for valid performance-based reasons, and has since had to defend against frivolous actions filed by him. So that is all to say, we were open to exploring a voluntary dismissal from Mr. Hodges. I'm not sure if there's going to be additional retaliation and frivolous suits or criminal actions or anything like that. I'm not sure. I may have to talk to my client again about whether we want to continue to seek sanctions, because frankly, this is, I don't even understand what the allegations are at this point. And I'm happy to argue the motion for summary disposition today too, but I guess I'm not sure, Your Honor. I'm not sure where to go from here, because I figured today would be trying to hash out how the voluntary dismissal is going to go, not new allegations about criminal conduct on someone's behalf. I'm not sure whose. And FOIA, I don't think is relevant in any way, but I assume that the court is aware of that as well.
Yeah. All right. Mr. Hodges, your motion for dismissal is not granted. Right on the form that's used, and it's in the statute as well, it says under section 2C, no answer or motion has been served upon the plaintiff by the defendant as of the date of this notice. And that is absolutely wrong. Absolutely. It's, again, an example of you misusing the law. This was filed with the court July 14th, this request for dismissal. And we received from counsel the motion to dismiss at the end of June 26th. So I'm not granting your dismissal. Counsel, do you wish to argue your motion for dismissal, summary disposition?
Your Honor, if Mr. Hodges would like to discuss submitting collectively an order of dismissal with prejudice of this action, we are happy to do so. If that is not the case, because as you've mentioned, it needs to be by stipulated order at this point because there's a motion pending. If that's not the case, then yes, we're going to proceed with our motion for summary disposition. So not to kick the ball to Mr. Hodges, so to speak, but we need to understand whether he is going to agree to dismiss this case or not. And if not, we will proceed with arguing the motion and seeking sanctions.
All right, Mr. Hodges, do you wish to seek a conciliatory agreement to not prosecute So the case will be dismissed without prejudice, or excuse me, with prejudice.
For this particular case, yes.
This is the only case that I'm aware of that is still pending. Go ahead.
Let's use small words and say them quickly. He said yes. What do you want to do next?
Your Honor, I think because Mr. Hodges is reserving his right to file more frivolous actions, I think we need to go forward with the motion.
Fine with me. Please argue.
Okay. Your Honor, just briefly, I know you have the papers. This is a frivolous action filed by Mr. Hodges. It's initially filed as a small claims matter, and there was given a short paragraph, a couple paragraphs about how Mr. Hodges is seeking the expenses of his legal work to file this claim, which I think comes out to $60, $70. Because Mr. McCune, who is my client and who is the chief executive officer and president of Wade Trim Associates, Inc., has, quote, maliciously escalated a business dispute with Mr. Hodges. There is no evidence that that has happened. Mr. McCune has defended himself in this case by filing a motion for summary disposition, and that's all. And even if there were anything, even if there was any cause of action actually pled, which there's not, there's no damages. There's Michigan, like all states, operates under the American rule. Fees don't shift unless there's a statutory exception or some other exception in case law, which there's not. So there's no damages in this case. There's no cause of action in this case. And Mr. Hodges' statement actually says itself that it is retaliatory and threatening against Wade Trim and Mr. McCune. And I quote, and I think I need to quote to understand or to put on the record how kind of incredulous this claim is. Mr. Hodges has pled that, and I quote, Andrew McCune and or his company are insignificant and irrelevant to me, to waste my time and valuable resources, and I hope this is a clear discouragement to any further illegal and adversary actions under Andrew McCune against me. I hope Andrew McCune will not mistake this as an encouragement for further retaliation and or adversary actions.
Now that could be construed as witness intimidation.
Your Honor, this case is being brought to threaten, to harass, and has no merit whatsoever. And I do think that in this case, because of what is going on and because Mr. Hodges is now threatening more actions against either my client or Wade Trim or other employees of Wade Trim, I do think that sanctions are appropriate, despite the fact that we are well aware that sanctions are generally reserved for situations where people are represented by counsel, because there is some leniency. But as we cited in our briefs, that leniency is not, it's not absolute. And I think to disincentivize Mr. Hodges from further abusing the legal system, who he has now threatened myself too, with some sort of vague allegations of criminality, I think that sanctions in the form of fees for bringing this motion are warranted. And that's all, Your Honor.
Mr. Hodges, how do you wish to respond?
Well, after termination, in order to get me further into trouble, they have made a false police report accusing me with false allegations. And in this process, it has the attempt to interfere with the protected activities, that is a criminal matter at unrelated place. So because of this action by Wade Trim, also involving Andrew McCune himself, this constitutes criminal activity for everyone involved. And that's the reason I prefer to see this as de-escalation. And I have attempted requesting mediations again and again, trying not to escalate the situation further. And Wade Trim has deliberately refused our mediation attempts, causing escalation to this point. And I have to bring this out for my own defense. And they get into something they have no idea, and the consequences can be severe, and I hope it can be avoided.
It could have been avoided by not filing bullshit cases against your previous employers for firing you because you were a shitty temp.
Your
Mr.
Honor.
Hodges, what police report are you referring to?
A
You've
police
not filed
report
any-
was
You've not filed any police reports with the court.
no. It's filed by Trim, and this was included partially in the material submitted by the counsel of Trim. By
Counselor,
Kent County Sheriff Department.
Counselor, you aware of what he's talking about?
Yes, Your Honor. There was a police report filed after. So I guess let me back up, Your Honor. Attached as Exhibit 2 is the affidavit to our motion is the affidavit of Andrew McCune. Attached there too are, I think, 60-something pages of very concerning, violent, threatening social media posts from Jeff Hodges that Trim became aware of after his termination and felt the need to file a police report, which is, of course, its right to do. We're not sure where that has headed because obviously Trim isn't conducting the role of the police. We just reported what we felt needed to report and move forward. Some of the reason that was reported was because there was a series of, which are highlighted in our briefs, Your Honor, a series of very threatening and violent statements that are made against employers and managers, and demonstrated a pattern from Mr. Hodges also, not only with the violent conduct, but his desire to use the legal system against his former employers. So that is the police report I believe he is referring to. That is not Trim's determination of whether the police are going to continue to investigate, but it is relevant for purposes of this motion, which is seeking dismissal of these claims which have zero merit, and Mr. Hodges has not made any argument as to why this case should not be dismissed, but also why there should be sanctions to halt these frivolous filings and to kind of cut it off now. As again, we were willing to look into a voluntary dismissal. We would need to agree to what the language was for the dismissal. But now apparently Mr. Hodges has further plans to file actions, and that needs to be stopped, and this court can do so by entering an appropriate sanction.
Thank you. Mr. Hodges, your claim, when it was originally filed under the small claims matter before it was moved to the district court, said that Mr. McCune maliciously escalated a business dispute under his instruction through some series of attempts to retaliate, harass, intimidate, or stalk you. Tell me how that occurred.
The general counsel, the description he has about the online posts, many of them dated exactly around the same time frame as this paper, September 13, 2024. They are protected activity, and any attempt to use it against me is a criminal. Please don't do that.
Mr. Hodges, what you're alleging is action taken by counsel after you filed your small claims matter. That you can't do something that happened after that to prove something that's supposed to be already in evidence. I'm asking for what evidence at the time that you filed your small claims case shows that Mr. McCune maliciously escalated a business dispute under his instruction.
By filing the police report, and
That's
there were
afterwards,
few
sir.
inquiries.
Sir, that's after you filed this matter. He responded in the way that he did. I'm asking you, what did he do before that you're complaining about originally?
This particular case was filed in May this year, and the police report was filed in late April this year.
So how is that in any way connected to the firing of you from Activent Incorporated when Mr. McCune works for is the owner of Wade Trim?
because in my LinkedIn history, there were few employees seeing my profile, and that's their time. They were using that information against me by filing a false police report in late April 2025.
So what is your proof that it's a false police report?
The false police report is included in your hands, and the local
What
prosecutor.
proves that it's false? What proves that it's false?
Because the accusation is untrue, and they are misused against me, and
Saying that
that's
it's
the protected
untrue and
activity.
it's false doesn't make it so. What's your proof that it's false or untrue?
The content is misused and irrelevant. Thus, it's an abusing the privilege to file a police report against me.
What is untrue about it? They just printed out what you wrote.
The action of your police report is frivolous. That's the point I have.
Say that again, because I didn't understand what you said.
It's the frivolous action by your victim to file a police report like that. And
What is the word that
it's
you?
an attempt.
No, the word that you're using before action. I don't understand what you're saying. It says I can't pronounce what you just said.
It's meritless for them to file a police meritless to file a police report, and it's a misuse of their position.
Why is that? Because you don't like it?
It's because it's an attempt of interference of their protected activity.
So you file an action against the boss of Wade Trim because you got fired from the company that is a temp service for you to work at Wade Trim, and now you're mad at them for getting out your posts on the public access social media. And again, I still see absolutely no connection between those things. Why is it wrong for them to find out what you posted?
Because those posting was a part of your larger protected activity to go after other companies.
Protected activity for what?
The whistleblower activity itself.
You're not whistleblowing. You're spouting off some political rhetoric.
Yes, which is
that's not
to get people
whistleblowing.
to.
And there's what case were you involved in at that time that you were whistleblowing on? Who did you whistleblow to? What protection did you receive from that agency?
You can probably subpoena that person, Neil, and I can provide the full name.
I'm not subpoenaing anybody. I'm not an investigator. This is a court. Where's your proof of any of those things? You come in here telling me that you're a whistleblower. I've got absolutely no proof of it. I see some social media posts of a man who's upset and is telling people how to do certain things if they don't want to get fired. You get fired, and now you're mad at them posting, having access to the very things that you posted about. What has that got to do with anything in this case?
That's when I was trying to talk to some of the employees of certain companies to get them to talk. So I can verify the information from within with the public information to verify the misconduct of certain organizations doing certain business, violating certain federal laws. And I submit such information to the particular federal agent that was cited, redacted in that particular email, creating the TCR. And I have redacted the full number of the TCR, but you can see the first two digits out of that, which is 14. There are around half a dozen TCRs being associated, and they are still actively working with me to continue the investigation to hold those companies accountable.
Mr. Hodges, you strike me as a conspiracy theorist of the worst type. You went into this, it appears to me from reading all of your statements in here, you went into this whole deal trying to figure out a way to sue this company, and you're not even suing the company that hired you, you're suing a different company that was engaged, had a place of business and you got sent there by the company that hired you. You got fired for being a bad employee, and now you're whining about it because your social media posts caught up with you. This is the definition of a frivolous lawsuit. The quote made by counsel is very telling. Even in your initial pleadings, you were telling them that you're retaliating and that you're doing things to set them up for harassment things. This is the worst misuse of the court system that I've seen in a long time. Your dismissal paperwork shows me that you're not filing things in good faith. I was the judge in your previous case against one of the other employees of Wade Trim. I dismissed that matter, and quite frankly, I was surprised that they didn't ask for costs and sanctions in that matter. So counsel, I'm granting your motion for summary disposition, and I'm granting your request for costs. Did you submit a proposed judgment to me or not?
No, Your Honor, we will do.
Jeff's case wasn't a conspiracy. It was a baseless claim that ended in sanctions. No evidence, no damages, no legal ground. Courts don't reward misuse of the system. Accountability matters. If this breakdown shocked you, like the video, drop a comment, and subscribe for more courtroom drama.